Good morning, everyone. This is the House Judiciary Non-Civil Committee. We're meeting this morning to consider 4 pieces of Senate legislation. We had a bill that we've previously passed out, was recommitted. I think there were some minor technical issues that were probably better solved here than someplace else. So let me go ahead and call Senate Bill 4. Senator Butler, I know, is here. I know Chairwoman Chambers is here as well, and whoever wants to come and speak to the substitute. I know Ms. Travis did some technical work over the weekend on it, and we'll just tie that up.
Thank you, Mr. Chairman. I want to especially thank Ms. Travis for putting us into the code section, so that way we have marshals, constables, and sheriffs included in this, and we do have representatives from the Sheriff's Association here in support of the legislation.
Could you give us just a couple minutes on refreshing our recollection on exactly what the bill does and then just what the changes encompass?
The bill allows the courts to put in their order dealing with restraining orders, protective orders, injunction, or any other similar court order requiring a constable, marshal, or sheriff to notify the person taking out the protective order. And this way they know it's been served and they can have the confidence going forward if they're stalked or harassed in the future. They would be able to pull out that restraining order knowing that the perpetrator has been served. This is an optional item that the judge will ask the complainant if they want to be notified or not, and that way it will be in the court order. And the senator reminds us that the notification has to be specifically requested by the victim.
Ms. Travis, can you just, if you would mind for the committee, just let us know what changes you made over the weekend, just structural?
I don't have the original sub before me, but it put it in the code section with the powers and duties of constables, and then the new language had all to do with marshals. And when you look in the chapter 10 around that area, it's 15-10-100 talks about constables. And I don't think there's a whole lot of jurisdictions that use constables, but they can, and they can allow them to serve under local legislation. So all I did was move this to a standalone code section instead of just putting it under powers of constables, because it never talked about a marshal. So I put it into a new code section and said marshals or constables can serve.
Okay. Questions for the author, Ms. Levitas?
I may, Mr. Chairman, actually just have an amendment at the time, at the appropriate time. That my question, I guess, to the author is, it says notification shall only be required if the protected person has requested notification. It later goes on and talks about the court saying that they have a right, they must notify the person protected. I'm assuming that the notification is by the person protected to the court at the time that the order is issued, or is it at any time to anybody? I'm just not sure who the notification goes to.
The notification would go to the victim.
I'm sorry, notifying that they want to be notified. It says notification will only be required if the protected person has requested notification, but it doesn't say of whom. Is that the court?
Yes, but the last sentence.
Well, the last sentence just says that the court's going to let them know that they have that option. But that particular line, and actually what I'm thinking is that the way this is ordered is a little, maybe needs to be reworked, that the last 2 lines actually belong at the top. It needs to be talking about at the time when a restraining order is issued, the court shall notify the person, then you talk about service, and then you talk about notification only being required. I'm just saying, to me, it's a little bit confusing and it's a little bit open-ended with regard to who's noticed. I think we can accomplish those things if we just reorder this and keep the same language essentially that you have. But my concern is that it's a little ambiguous.
I will defer to the wisdom of the committee and legal counsel in that regard.
Thank you, Mr. Chairman.
Ms. Abrams?
At the appropriate time, I'd like to be recognized for a motion.
Okay. Mr. Franklin?
Thank you. Good morning. Welcome to the fun committee. Just a question. The sentence starting on line 16, the notification, and then it's twin over on the next page. The notification required by this code section shall be made within 24 hours following the service. I'm just wondering, what type of burden are we going to be placing on the marshals and the deputies to follow up with a notice that that the restraining order has been served? Is this going to impair their ability to do needful law enforcement work when anyone could call in or go on a website possibly to see if a restraining order has been served?
Right now, it is my understanding, Representative Franklin, that most all sheriffs and marshals are already performing this. This allows it to go into the court order, and quite frankly, it is part of their law enforcement duties to protect victims of crime in this regard. And so it would be my personal opinion that no, this would not be an added burden, and that's why representatives from the Sheriff's Association are here in support of the legislation as well.
Is there a place where, on a website that would list who has restraining orders taken out on them, and so people would be able to know and could go there as well to see?
Yes. As a matter of fact, the GBI has one that's submitted list by the Superior Court clerks, and that is collated and put out daily. It is oftentimes behind because it may take a day or longer for it to be submitted to the GBI. Then the GBI has to do data input. So by being personally served, the victim can know, if not hours, perhaps even days ahead of time, that the perpetrator that is victimizing them has been notified.
Great. Thank you.
Ms. Berg.
So I just want to be sure I understand. This is already being done, and now we're making a law for it to be done?
This allows the courts to actually put it in their court order.
Okay, so prior to this right now, when someone has a restraining order against someone and it's filed, what happens?
It's not required. The victim is not required to be notified.
Okay.
Many of them do it as a courtesy and believe it as follow-up, but this requires it all of them to do it.
And also, if I had a restraining order against someone, wouldn't it be my responsibility to call to find out if this has happened, if the court system has done it?
Well, the court system won't be doing the notification. It'll be the sheriff or the marshal or the constable themselves. that will be
Right.
doing
So
the
if I had a restraining order, could I call personally to ask?
You still could, yes.
Okay. Very good. Thank you.
Mr. Evers.
Mr. Chairman, I was in the same posture as Representative Abrams.
Okay. I see no further questions for the author. I see no one sign up to testify on SB 4. Ms. Abrams.
I'd like to move do pass SB 4 LC 294406S.
Ms. Abrams moves due pass of SB 4 by substitute LC 294406S. Second by Mr. Everson. Are there any amendments? Mr. Levitas.
Mr. Chairman, I'd like to just give this one try, and if it's too confusing, I certainly don't want to hold up the committee's time, but I'd like to explain my amendment before I even attempt to describe it. I find the order of this a little bit confusing. We start with the first few lines talks about where the order is served. Then we go back to notification is only going to be required. Then we talk about notification being made within 24 hours. And we end by talking about the person shall notify the person, the court shall notify the person of their right to be notified, comes at the end. It just seems to me where we need to start is at the time that the order is issued, the court notifies the person of his or her option to be notified. After the order is issued and the marshal serves it, they are going to notify them, provided, however, that notice is only going to be required if the court, if there's been a request of the court and that person, the protected person, has provided their telephone number to the marshal within 24 hours, and then concluding with the notification made within 24 hours. So the way that I would respectfully suggest that this be worded is as follows, and I'd like to read it through without doing the inserts and just read how I would have it done just for clarity purposes. Beginning on line 10, at the time a restraining order, protective order, injunction, or similar court order relating to harassment, workplace violence, domestic violence, stalking, or elder abuse is issued, the court shall notify the person requesting protection of his or her option to be notified as provided in this code section. After such order is served by a marshal or constable, such marshal or constable shall be required to notify the protected person by electronic or telephonic means that the order has been served on the restrained person, provided, however, notification shall only be required if the protected person has requested notification from the court and has provided a telephone number or email address to the marshal or constable for purposes of notification. The notification required by this code section shall be made within 24 hours following the service of the order and shall include the date and time when the order was served. And I would make a conforming change to lines 25 through 34 that deals with sheriffs.
Is your point that the structure of your language is more chronologically consistent?
It's not only chronologically consistent. I think that at a minimum, without talking about who the person requests notification from, they could request notification from the DA, a police officer, but it is chronological. I think it makes much more sense to talk about the order being issued than talking about what happens afterwards in provided language. To me, it is a little bit confusing to begin with the service, go back to when it's issued, and conclude again with that the court has a duty to notify the person. To me, it's confusing. If it's not confusing to any other member of the committee, then I will withdraw my proposed amendment. We'll just move forward.
Let me ask Ms. Travis if she has any heartburn about that.
No, I think it's great.
Okay.
I just think it makes sense.
Okay.
I can't say that I got every single word, but I'm sure.
I don't think anyone did. Let me ask Mr. Levitas to go ahead and
I'm not sure I did, Mr. Chairman.
Let me ask Mr. Levitas. Right. Presupposing that the author did, let me go ahead and ask Mr. Levitas to, from a striking insert standpoint, very slowly for counsel, unless you've got you don't have a print to do.
I've got some of it, but I don't have
And
Okay.
what I could do, Mr. Chairman, it's up to, obviously, to the chair and to the author, but what we might do is if we could just maybe hold the bill for just a minute or two, let me get together with Ms. Travis. It might expedite things rather than do it that way, but I'm happy to do whatever the chairman and the author wants to do.
The other three bills that we have are ones that I would be hesitant to.
Okay.
Why
Okay. Well,
don't
then
we talk through it slowly?
Okay.
Let's go ahead and do that.
All right.
I just don't want to break off when these other bills are going on.
Absolutely. All right.
Okay.
Beginning on line 10, striking the word where and insert the words at the time. That continues, then continue with that language all the way to the word is on line 11, which is the third word from the end there,
Right.
and insert the word issued.
And you pick up from line 18, 19, and 20 all the way to the end of that sentence.
Striking at the time an order is issued in line 18, and then picking up exactly with the rest of that language.
Right. Gotcha.
Then period after the word section, which is moved from line 20, and begin with the words after such order is, and then pick up on that language. All the way through line 14 with the first word person, changing the period to a semicolon, inserting provided however, in changing the N on notification to a lowercase n. On line 15, after the word notification, first word on that line, insert from the court, and that would be the last change.
Okay, I lost it. I'm at provided, however, I thought you then said notification required by this subsection shall be made within 24 hours following the service of the order.
Right, I'm sorry, you're absolutely right. I read the wrong notification. You're absolutely right. You would move line 16 and 17 would come after the provided however.
And then the last sentence.
No, I'm sorry, Ms. Travis. That's correct, the way it is. In other words, you would say that they're required to notify you. However, they're only required to notify you if you've requested it from the court and you've given the email. So that actually, those lines would read the same way. So you would begin with the issuing of the order, the service of the order, notification of the order, and it would go in that way. Right after you've talked about serving the notice, you have the provided, however, notification shall be required only if the person protected has requested notification from the court and has provided a telephone number, email address, the marshal or constable for purpose of notification. The notification required by this code section shall be made within 24 hours following service of the order and shall include the date and time when the order was served.
Is there objection to the amendment? Is there objection? Without objection, the amendment is adopted.
And Mr. Chairman, I would only respectfully request that we make the same conforming changes to lines 25 through 34 to comply, to make the language identical to the changes we've just made.
Ms. Travis, is that clear as it relates to
I'm with you.
the other side? Any objection to that? Any objection to the second amendment, second Levitas amendment?
No objection to the second amendment.
Hearing none, the second amendment is adopted.
Yay!
Any further amendments? Seeing none. Any further discussion? Seeing none. On the gentlelady's motion, Ms. Abrams, of due pass by substitute of SB 4 LC 2944006S. All in favor say aye.
Aye.
Opposed? The ayes have it. The motion is adopted. Thank you.
Thank you, Mr. Chairman, members of the committee,
Okay.
and especially Ms. Legal Counsel.
And thank you, Mr. Levitas, for that.
Oh, I'll make sure I thank him well on the floor tomorrow.
That was a good amendment. We considered our last meeting SB 364 by Senator Staten, and I know that folks in the Secretary of State's office, Mr. O'Sullivan and others, have been working with Chairman Staten. Come on forward to address some of the concerns that that committee members had expressed, and we wanted to go ahead and give it the weekend and see what we could do at finding a consensus on that. And you should have, members, you should have a substitute in your file folder. LC 294402S, is that correct?
That is
Okay,
correct,
that's the
Mr.
correct
Chairman.
version of the substitute. And Senator, if you want to, maybe the most efficient thing to do would just be to go ahead and talk to the changes.
Thank you, Mr. Chairman and members of the committee, and I too want to thank Ms. Travis for her work over the weekend together with Michael O'Sullivan of the Secretary of State's office in trying to get to some of the concerns that were expressed last week. I think you will find that the changes that we have made are on page 2 of the bill under section 4. There was some concern about the general nature of the language in the original bill, which said believed to be acting in violation of, and we have changed that or removed a sentence and brought the wording to some clarity by on line 58 saying found by the board. So we hope that that's an improvement. And then what we've done as well, if you'll turn to page 3, line 61 of the bill, there was some concern about how much authority we were giving to the board, and we have reduced the fine, which was originally $5,000 for each violation, down to $500 for each violation. And in fact, in checking with the Secretary of State's office, this is exactly in keeping with what other boards, the authority that they have in terms of the level of the fine, and also the clarification of the language found by the board. So we hope with that, Mr. Chairman, that we have met the concerns that were expressed when we met last week.
Questions for the author, Mr. Levitas?
Just like to be recognized for motion at the appropriate time.
Okay. We've got a few folks signed up to speak. If on 364, we welcome that testimony. I would just simply ask that it be kept as brief as humanly possible for Senator Staten's time and for the other authors of bills that are pending right now. Ted Baggett with the Georgia Municipal Association.
Mr. Chairman, in the interest of time, I'll wait unless somebody has questions about local governments in Section 5 of this bill.
Any questions from? Thank you, Mr. Baggett. Any questions from Mr. Baggett regarding impact to local governments and their operations? Seeing none. Shelley Centerfit with Georgia Women for a Change.
Mr. Chairman, in the interest of time, likewise, we just urge your consideration.
All right. Thank you, Shelley. Any questions from Ms. Centerfit? Seeing none. Mr. Levitas.
Mr. Chairman, I'd move that we do pass the substitute to Senate Bill 364 LC 294402S.
motion of due pass by Mr. Levitas of SB 364 LC 294402S, second by Mr. Everson. Are there any amendments? Seeing none, any further discussion? All in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it, and the motion is adopted. Thank you,
Thank
Chairman
you, Mr.
Staley.
Chairman, members of the committee, the people of Middle Georgia, thank you as well.
Thank you. Moving right along. Senator Calzert, is he here? Yes, sir. Thank you.
I'm sorry?
SB 180, just to refresh the recollection of members,
Right.
passed out of the committee last year, fell into the
I just got an email from my secretary that it's done, but I want to.
the rules process, and then obviously was recommitted here. We have a new. The language that you have here is different. If I'm Senator, if I'm recalling correctly, the substitute that you have in front of you is not the language that we passed out last year. So if you would take a look at it, I'll ask Senator Calzert if he would. It's been a year, so if you could refresh our recollection on the general subject matter, and then if you could speak to specific changes that were made relative to what we passed out last year, and then what is before the committee today, that would probably be the most productive. I'm looking for the substitute as I speak to you. It is LC 294391S. Is that correct?
That's correct.
Okay, LC 294391S. Senator Calzert.
Thank you, Mr. Chairman. Let me give a little background on this. This involves limited driving permits for people convicted of DUIs. Current Georgia law does not allow you to get a limited driving permit on a second DUI. If you're convicted a second time for DUI, you have what's known as a hard suspension. It's a 2-year suspension. There is a provision to get it back a little bit earlier if you put on an ignition interlock device where you have to blow in it to prove you hadn't been drinking before the vehicle will start. I can't recall whether that's after 12 months or 18 months you're entitled to apply for that. But up until that point, you may not drive at any time for any reason if you've been convicted twice. Now, we've had a very successful DUI drug court program in the state of Georgia, and my local state court judge, Kent Lawrence in Athens, really pioneered that in the state of Georgia, and they are extremely successful. A DUI court is a very intensive probation where you have to come to court literally every week, and you're subject to drug testing, alcohol testing, very responsible probation. You're held accountable if you in any way step out of line, and you must participate in drug counseling and treatment, alcohol counseling and treatment. The idea obviously is to rehabilitate these drivers that are repeat DUI offenders, cure the problem so they stop committing the offense, and they are extraordinarily effective. Extremely low recidivism rates if you participate in those type of DUI courts. So we want to keep people in those programs, incentivize them to do it. What's happening is people that you only get in those programs if you're a multiple offender. The first DUI doesn't do that, but if you get a second DUI, you can be put in that program, and it lessens your confinement time and helps you get rehabilitated. They're finding that some of these participants can't get there. They can't make it to the probation meetings every week. They have to appear in front of the judge. They can't get to their alcohol treatment and counseling programs because they can't drive, and because they don't have any mechanism to do that. So this was brought to us by the Council of State Court Judges, and predominantly state courts have these DUI courts because they handle misdemeanor offenses, which are DUIs. Superior courts are handling felonies, so they may have DUI drug court programs, but they tend to be more focused on drugs because they're handling felony drug offenses up there. The State Court Judges Council came to me last year and asked me to support this bill because they want to promote their DUI courts and the rehabilitation of alcoholics, basically, are folks that drink and drive. It was supported by them. It was supported by Mothers Against Drunk Drivers, who also share that same mission. So let's rehabilitate, cure these people that are repeat DUI offenders. Passed the Senate. I think it was unanimous. It passed out of this committee unanimously last year. Got hung up in rules. In the interim, the Department of Driver Services came to me and noticed some glitches in the bill that didn't properly align basically the lengths of suspension if you have a temporary driving permit versus if you didn't have that. Because you can't get your real license reinstated until after 18 months if you've been on an interlock device at least 6 months now. That's the rule. You would have to be a pure hard suspension for 12 months. Then you can apply for your interlock ignition device, keep that in effect for 6 months, and then you can get your license reinstated. And that's to encourage people to do that. The original bill said you had to have the interlock device on for 6 months, just like current law is now, but it didn't take into account that you could get your license back quicker if you had the temporary permit and then the interlock device. You could actually get it back after 10 months, which was not our intention. So they wanted to lengthen the length of the suspension, and so they had to make these technical corrections to the bill. And of course, I didn't object to that. Let me go over what the bill does. So that's the technicality, what we changed from last year. But the idea behind this bill is that if you're a second offender on DUI, you would be able to get a limited driving permit under very strict conditions. First of all, you would have to be involved in a state-mandated substance abuse treatment program or a DUI court. So that there are provisions where you can go into rehabilitation treatment or you can do this intensive probation under DUI court. Both are provided by state law. So this would only apply if you were getting rehabilitated under a state-mandated program or through a DUI court program. If you're in those conditions, only if the sentencing judge agreed, so there would be no right to this, the same judge that sentenced you on that DUI and put you in his DUI court program would have to agree that you were a good candidate to have a limited driving permit. In his discretion, sole discretion, he could give a limited driving permit to you if you were participating in drug treatment or in the DUI court program. You would have to have finished a clinical evaluation to determine that you have a drug or alcohol problem, which pretty clearly you're going to if you're having multiple DUI. And you have to be enrolled in that abuse treatment program or enrolled in a drug court program. And you would have to have this interlock ignition device installed in your vehicle, any vehicle that you might be operating. And you would have had to have already completed a DUI school. We have DUI schools, that's a part of your sentence on DUI. And they would have to give you this certificate of eligibility. And even under those conditions, you wouldn't be entitled to it until 120 days has passed. So let's just look at it this way. If you have gotten your clinical evaluation done and enrolled in a treatment program or DUI court, and you've completed DUI school, and you've waited 120 days, and you've put an interlock ignition device on your vehicle, and the sentencing judge agrees, only under those narrowly defined circumstances you would be entitled to have a limited driving permit, and that's to enable these people to participate in the programs. And what we've done is say then you would have to keep that. You couldn't get it till after 4 months. After the 120 days, you would have to keep that on your vehicle for 14 months, so it would run you out to that 18-month period before you could apply to have your normal driving privileges reinstated. And that coincides pretty closely with the length of these DUI court programs. They're generally 18 to 20 months is the length. So that's, you sort of cuts to the chase of what this bill does. I think it's good public policy for us to rehabilitate drunk drivers rather than just throw them to the winds and let them fend for themselves. This accomplishes our goal of reducing drunk driving. Now there's one other provision in here that sort of puts a hammer on them too. If somebody that's been granted, and this would be in the last section of the bill, section 6, if somebody has been given one of these limited driving permits under these finite circumstances and they violate them, because these permits don't let you just drive anywhere you want to go. They limit it usually to go to work, to go to school, to get medical treatment, or of course in this case to attend your treatment for your alcohol problem or your DUI court. But if you're doing it driving at night, you're going out, you're on vacation, you're driving outside the bounds of that limited driving permit, then they will revoke your probation. And if that happens, your driving privileges will be suspended for a year from the date of that revocation. No more Mr. Nice Guy, no more opportunity for a limited driving permit. If you were to have a second violation, then it would be a 5-year suspension. So this is granting these people a chance to do right and be rehabilitated. But if they don't take advantage of that chance and they violate the terms, then you drop the hammer on them and all bets are off. They're a hard suspension either for a year or 5 if they were to do it twice. And Mr. Chairman, I'm happy to answer any question. That's as best I can explain it. I do urge favorable consideration and passage of this bill out of committee. Thank you.
Thank you for that summary, Mr. Knox.
I know Senator, you were reading from the summary, and I applaud the effort here. But but as I read line on page 8, line 264 through, be sure I've got the right line now. You were speaking about that it has that it has to occur before the sentencing judge. I think I'm reading that it has to be such person by the court. That's line 265. To such person by the court in which he or she was convicted.
That's the judge. That's the judge that will give this. As I was going through the conditions, the sentencing judge would have to agree to give you the limit.
Well, I guess I was getting at the point where the language says the court. The court is the state court that it was issued, that the sentence was delivered in, because otherwise you might be requiring us to go find the judge who was, judge for the day, or who's now no longer on the bench. That's not what this. You're not interpreting that line. You just So it's just the court has to be that same court where he was convicted, not that same judge.
Right. The way the system operates is every court operates the same way. They're going to assign cases to a judge.
Right.
And so it would go back to that assigned judge unless something like you just referenced occurred, the judge had retired or resigned or something, then it would be.
I just want to be sure I wasn't missing something.
I expect, in real life, I think this would happen very shortly after the conviction. You're talking about 4 months after you're convicted being applying for this type of a limited driving permit, and so ordinarily the same sentencing judge would be on the bench, but there could be circumstances where that happened, they retired or whatever.
Ms. Abrams. I'm sorry, Mr. Mangan.
Yes, thank you. Thank you, Senator. Thank you, Chairman. Thank you for this fine legislation. And I'm not a criminal lawyer. I preface my statement with that, as I so often hear so many of my colleagues here say they're not a lawyer. But I'm not a criminal lawyer. The length of generally, and this may have been answered, but the length of probation, I see in here that after 14 months they may reapply for reinstatement of his or her regular driver's license, and you just spoke about in Section 6 about if they violate, you can revoke the person's probation. Now, probation can ordinarily be much longer than 14 months, so you can revoke the remainder of the probation. How long are the terms of probation generally? Right. And so that I'm understanding the length of time that you're revoking, because I know you're not just revoking the driving privilege, and if you would answer that, and I didn't do it, but I want to say thank you for this legislation, because we're paying so much money for keeping people in jail that are kind of, we can find a way. If we're paying $24,000 up to keep them in jail a year, I really applaud. This also impacts our budget, what your legislation does. So thank you. But if you can answer that question about probation.
I can. A DUI, at least certainly a second offense, is a misdemeanor offense, so the length of the sentence is limited to a year. Okay. That's the difference between a felony and a misdemeanor. It can be more than a year if it's a felony. But there are usually multiple counts. There's some underlying driving offense ordinarily and the DUI. The DUI court programs do not let you participate unless you're on probation for 2 years. Okay. And sometimes more. But generally speaking, because that program is designed to be 17 to 24 months, you're not eligible to enroll in that unless you're on probation for at least 2 years. So, and you are correct. This is referencing the implications on your driver's license if your probation is revoked, because you're going to lose it for a hard year, at least if you do that. But there would be other implications. The sentencing judge could revoke the remainder of your probation and let you spend the remainder of that sentence in jail or any portion of it. And what they tend to do is kind of a graduated program. The first time you step out of line, they may send you to jail for a weekend or 5 or 10 days or whatever. And if you say you tested positive again on an alcohol test, then they're more likely going to be 30 days. And then, eventually they just give up and just lock you away because you're not responding. But
Thank you.
that's how that would operate.
Appreciate it.
I see no further questions.
Thank you.
Bob Bray is. Oh, Mr. Collins, did you have something? Oh, okay. Bob Bray is with the Council of State Court Judges.
Good morning. I really don't have anything to add to that, other than if you have any questions, I'll be happy to answer them.
And this legislation comes at the request and with the endorsement of the Council of State Court Judges. Any questions for Mr. Bray from the Council of State Court Judges? Seeing none, what's the pleasure of the committee, Mr. Collins?
Motion to pass LC 294391S.
Mr. Collins moves due pass of SB 180 LC 294391S, second by Mr. Mangum. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? No. The ayes have it. The motion is adopted. Thank you, Senator Calvert.
Representative Ramsey would carry this in the House if that's acceptable.
Absolutely. Thank you. Throwing the dice, but that's up to you. There's a motion for reconsideration on the table. All right. Senate Bill 391. Senator Unterman, thank you for your patience.
Thank you, Mr. Chairman and members of the committee. As y'all know, we have a new Department of Behavioral Health and Developmental Disabilities, and at the beginning of the session they asked me to carry this bill, Senate Bill 391, and it's LC 294206S. It passed the Senate unanimously, and it deals with children who have a behavioral problem or developmental disability, and it authorizes the department to be able to place them in a secure hospital or community facility designated by the department. And the impetus for the bill originally was to expedite services for these children and also to be able to save money to get them moving through the system more quickly. It didn't have any problem in the Senate. Last week the department came to me and asked for an amendment, and unfortunately I didn't get it to you until this morning. And it expands, the amendment expands not from just children, and I think they took that from line 61 if the defendant is not a child. And the department is here and is going to talk about what the amendment does. I talked to legislative counsel, and it just changes some definitions about administrative officer in terminology, and the department says administrative law judge, that it has to do with the Olmstead court case and what they're working on. So with that, I would ask that you would let them speak about the amendment.
Any questions for Senator Unterman? Seeing none, thank you, ma'am.
Good morning, Mr. Chairman and members of committee. My name is Consuelo Campbell. I'm Director of External Affairs for the Department of Behavioral Health and Developmental Disabilities. And I have with me this morning Betty Bentley Watson, who's an attorney with our department, to explain the legislation to you and the amendment, if you will.
If you could, just from the department's perspective, take a giant step back and, sort of give us a big picture of where we've been, where we are, and from your perspective, where, how we got to this particular.
Sure. I'm going to punt to Betty because of some legal proceedings that we've been involved with.
Mr. Chairman, good morning. Were you speaking with respect to the amendment or just generally?
Just generally from the department's perspective. It's a new department. I know y'all are getting your footing still, and which is fine. Just the issues that have come up, what current problems, proposed solution, the perspective on it. Just give us a real big picture, because you're looking at these things on a daily basis. This is the first time that many of us are looking at this. So
yes, sir. That's actually very helpful to our presentation of the bill. The bill itself deals with forensic services for youth, and as you can see, it assists the department in complying with the Americans with Disabilities Act and also with the Olmstead law. While these youth would be in a secure facility, it is clinically much more appropriate to have youth placed in a youth-only facility. We, as a department, have been moving very aggressively toward compliance with the Americans with Disabilities Act and the Olmstead ruling by the United States Supreme Court. Commissioner Shelp has done a lot of hours on the road, meeting with people, stakeholders of all sorts, and one of our primary goals is to develop new community relationships, new partnerships with academic institutions, with other medical facilities, and to do what we can to redirect services to create a new system for serving persons with the disabilities in our mental health code. The amendment that we are addressing deals with persons with developmental disabilities. The short story on this is that we would like to close the door for hospital admissions for developmental disabilities purposes by July 1, 2011. We are trying very hard to get people placed into the community and make sure that people in the community are getting waiver services that they need for developmental disability services. The amendment that we are putting before you it has some bridge language that will allow for the time period of a year for us to have people place the developmental disabilities admissions, which occur really only when someone is in a crisis situation. At this point, they go to the hospital, and that's all that the law provides. We'd like for you to help us place bridge language into the law so that for a time period of a year, people can be placed either in the community, in facilities that the department would designate, or in hospitals. Then after a year has passed, we feel we will have developed the community facilities sufficiently for folks to be admitted for crisis services only into facilities that are designated by the department. And that's really the short of it. The amendment appears to be a lot longer, more complicated than that. It's because we've made a couple of definitional changes to change the term hearing examiner, which really is obsolete in law and in practice. As you know, y'all passed the law a few years ago for the administrative law judges in the Office of State Administrative Hearings to handle procedures such as these. We've made that change, and then a definitional change from the term superintendent, which comes up in the legal procedures, and that's really a term defining the executive officer of a hospital. We are proposing the term administrator, who would be the administrator of a community facility. Some of these facilities may be state-operated, some may be private. We don't have the final answer on that, but this would be a tremendous help for us specifically in our negotiations right now with the United States Department of Justice in the case that they have against us that has to do with both hospital services and with the Americans with Disabilities Act. They have a very, very strong push to move people into the community. And this is certainly where we want to go, so we will be happy to answer questions on this. Appreciate your time on it.
Mr. Levitas.
Thank you, Mr. Chairman.
Oh, sorry.
First of all, let me say I want to do what I can to support Senator Unterman's good bill here, but with all due respect, this is much more than just a few definitions being changed. I mean, I'm looking at LC 294206S, and it's essentially the same language repeated a couple of different times that has to do with somebody being mentally ill or developmental disabilities. And I'm looking through your amendment, and I guess ultimately what I'm going to ask you to do, and I with all apologies in advance to members of the committee, is walk us through more carefully these changes, because I'm looking at Section 5 where you've completely removed respite care. It goes on, and it's a little more than just definitions, and I'd like you to really walk us through section by section, if the chairman will indulge me, the changes that you've made. Because to me, it's more than just replacing superintendent with ALJ or adding the word administrator, and I don't care if you skip over that part of it, but there's some substance in here that's very different than just changing a definition. And I'd also like you to address, while it may be in compliance with the ADA, I view moving from a state hospital to mandating community care as being a shifting of yet another unfunded mandate from the state down to the communities, by saying we're taking them out of the state hospitals and you communities must accept them. And I understand y'all have burdens placed on you by the ADA, but that is, if we're not appropriating the dollars up at the state level, and that really falls on legislature, then we're just once again shifting burdens from state government down to local government. So, Mr. Chairman, I guess first I'd like to ask whether that would be acceptable.
No, it's more than acceptable, and let me just give it to you straight. This is a pretty big change as far as we see it, and it's the type of thing that warrants conversation ahead of time, just to get people in a place where they need to be. And no one here in this committee has had this conversation. Of course, I know that Senator Unterman, on the side of Angel, so often as she is trying to do the right thing. But it's the type of thing, especially given the weight of the amendment, both substantively and literally, that we're getting this morning for the first time. And I understand that we're all multitasking to a dangerous degree at this point under the conditions that we're under. But Mr. Levitas' point is well taken. I think it would be helpful both to the issue and to the committee to walk us through a little more carefully what the changes are. Senator Unterman and I spoke earlier before the meeting, and that given the changes and that we're seeing it for the first time, we do well to go ahead and hold it for a meeting. We're going to meet again to see if we can meld the original and the amendment, because it is an amendment, not a substitute, together, and that's in combination with, I know, some structural issues that council has brought up to me this morning already regarding where this is in the code and where the original bill's in the code as well. So we've got some substantive and logistical issues to work out. Beyond that, Mr. Levitas' point is well taken. So I would ask you, for purposes of potentially expediting the bill for the next meeting, to walk us through more carefully this meeting. It's a recess day, so we've got a little more time, so that members potentially can get to a comfort zone the next meeting, by which time council will have been given the opportunity to hopefully be able to meld the two into a workable work product. And I hope that's reasonable. So let me turn it back to you and walk us through, if you would, as per Mr. Levitas' request.
We appreciate that very much. And first, I think it's helpful to understand that the timing of this amendment, both in the time that we present it to you and in the implementation of it, is critical to understand. This came pretty much from the DOJ negotiations, and I can't speak to all that's going on there, but it's certainly publicly available information that the Department of Justice is extremely interested in ensuring that persons are served in the community and not in state hospitals. The timing of the bill otherwise has to do with our implementation and how and when we can comply. Because people can be admitted to the hospital at this point only, or can be served with crisis services only by admission to the hospital, a change in the law would be necessary so that people can be admitted to crisis services in the community. We need for that to happen now, so that those services can start to happen in the community, so that we, in order to get by July 2011 to the point where we have sufficient services to provide. In other words, if we were to come next year and say that we want similar terms, we may not have the resources in the community built for that, and we may not have the legal procedures down sufficiently. So this is giving us a a bridge time when we can implement, essentially. But to go through the bill, the definitions that we refer to are in the first or section 2 of the amendment. You can see we're changing the term administrator, and we are changing the criteria in lines 23 through 30, changing the criteria for temporary and immediate care, that is crisis services, to delete the lines on 29 and 30 for whom there exists no community services. Community services is exactly where we want to go with this, so that's the reason why that's deleted. Then you can see the deletions of the administrative law judge and the change to the definition of an administrator, deletion of the definition for superintendent. In section 3, that is just. That is something that actually Commissioner Shelp personally felt pretty strongly on this. The term superintendent really just in the field refers to the chief administrator of a hospital, and the services that we're putting into the community where the chief administrator would be really just an administrator and not a superintendent. So in section 3 of the bill, this is just changing the term or deleting the term superintendent because it's would no longer be in usage. And section 4 of the bill talks about services to children. You can see the change of adding the word administrator, but on page 4 at the very top, the language says that the department would be able to designate facilities in the community where children can be served. This is lines 102 through 104. The deletion that you mentioned about respite services is basically making true legally what is true in fact now. We are providing respite services in the community now, and we don't intend for those services to be provided in the hospital. So that is just simply making that true in the law. Section F is the legal procedures for. Right, this is the legal procedures, the court petition that can be filed for housing someone in the hospital, and so this is just making changes in the legal procedures that are consistent with the placement of people in community facilities. And again, switching out the administrator. Line 144, we cross out the term from the department. It is not known specifically right now whether all these services will be state-provided, state-operated services, or some that would be essentially provided by the department but through contracted services. So we're deleting that to make it logical. Section 7 really is kind of the heart of the bill. This is the part of the code where a certificate is issued for someone who needs temporary and immediate crisis services. And the change is primarily in lines 167 and forward, where it's described that we're retaining the current language in lines 155 and forward, subsection B, and in subsection 2, which is being added, we are adding there an option for a person in crisis to be served in a community facility that would be designated by the department. We would be designating facilities that would be available on a regional or community basis to serve folks. We want to try to cover the state appropriately geographically and help provide these services close to home. And then lines 181 through 184, this makes the change to community facilities from the hospital, and it says that the subsection will be repealed as of June 30th, 2011, meaning that after that time, services would be provided only in the community. It's the same language in Section 8, This is just at a different legal posture. Yeah. Right. This is just in a different legal posture where after the certificate has been filed, and where we are going through court proceedings. No, I'm sorry. This is the temporary certificate in section 37-4-40.2. So it's the same language as in the previous section. And section 9 is simply adding that any hearing that would take place could come from a facility, meaning a hospital, or a community services provider. The following section is a section that actually provides, let me find these exact words, line 244, if you can read through the strike-throughs, it refers to placing someone in a more restrictive setting if that's needed. In other words, if the person is not compliant with a treatment plan, we want to strike this code section because we are not intending to place people in a more restrictive setting. That's just simply contrary to the Olmstead opinion and to the Americans with Disabilities Act. So the community facilities that we will have will be sufficient for services that are necessary to provide. Section 11, when a person needs a long-term placement in a community service after the crisis has abated, there still may be a legal commitment necessary, and that is where this section of the code occurs. This is simply changing the terminology to community services provider and administrator, adding the term administrator so that either an administrator or a regional state hospital administrator can go through the procedures, the court procedures for having someone under court order to remain in one of these facilities. Let's see, section 12 simply deletes the statute that provided for appointment of hearing officers, which is no longer done because the Office of State Administrative Hearings handles these procedures. And then in 37-482, this is just replacing the terminology hearing officer, hearing examiner with administrative law judge. And the section which talks about the fees to be paid, that's not an issue. Section 14, again, it's just striking the word superintendent. The word administrator is already in that particular section. And section 37-4110 is regarding the appeal rights of clients, and this is just in this section switching over from hearing officer or hearing examiner to administrative law judge. There are a couple of places not relevant procedurally to the substance of this bill where the term superintendent appears in the code. Section 16 just swaps out the term administrator for the term superintendent in the places that term appears. I hope that's helpful. I know this is.
I
know this is fast.
And if you address this, I apologize in advance.
Yes, sir.
Talk to us about the overriding policy, the effect of the implementation of lines 102 to 104. The department may require that services under this code section be provided by a community services provider or facility designated by the department and not by means of admission to a state hospital facility. What are you seeing in terms of what it is that patients need, when they need it, and so forth, that would require that type of decision? Because obviously from a patient impact standpoint, that's potentially significant. Mm-hmm. And so what is it that you're seeing from a what's really needed standpoint in terms of treatment? What it is the state is doing, is what the state doing now, I don't want to call it overkill, but is it more that's needed? And then what safeguards will be in place so that, the department may think that admission to a state hospital facility may not be warranted at one point, but that of course can change. what is it that's going to happen in terms of process, in terms of monitoring, so that if a patient's needs change and they do need to go into a hospital, state hospital facility, and not a community services provider, talk to us about the mechanics of how that'll work so that there'll be a seamless process such that patient care, patient safety will not be compromised.
All right. The degree and the level of services would essentially be the same. It's very much about the setting. It's very much about changing from a large institution-based setting for services to smaller services. Crisis services, in many instances, we are already providing in the community. They just may not always be necessary in residential terms. Sometimes you can provide crisis services that would be in the home, that would be at a day provider, something like that, and it's not necessary to move the person from their own home. In situations where it is necessary for the person to be removed from their home, a legal process is needed, and that's what the law already provides for. We're just changing it to a community services provider rather than a hospital. The community services providers these services would be primarily provided through waivers, through our existing waivers, and we would be continuing to build on the systems that we have already for consumers' rights, for monitoring. We already have a strong policy and practice of, for instance, reporting incidents that occur in certain types of incidents that occur in community settings that get reported up to us. We require follow-up on those. We also are developing even more our administrative structure within the department for following up on the quality of services and making sure that consumers' rights are addressed as well. We do have with us today Beverly Rollins, who is the head of our section on developmental disabilities. If you have specific clinical questions, or if I'm not getting to quite what you need.
No, I appreciate the response. I'm looking at the amendment, and I looked at the underlying bill as well, and I didn't see, and I may have missed it, I didn't see the community services provider as a defined term. Talk to us about, when you say community services provider, to me that's that could be anything. When you're talking about to a lot of us, again, we don't live this on a day-to-day basis. We know what a state hospital facility is. Talk to us about the various types of community services providers that we're talking about in lieu of a state hospital facility.
All right. Community services is a term that's actually defined in the code already. It doesn't appear in this draft, but it's simply because we're not making a change to
Sure.
it. It includes residential services, which is the key thing that
is that home health
be needed
or
in crisis.
home health providers, or
no, not necessarily home health. This is in the developmental disabilities setting. It would include habilitation services. It would include day habilitation services. It would include having case managers.
So it's all outpatient. Is that what it's outpatient?
Yet outpatient, but it would be outpatient in terms of not in a hospital, but
right.
There would be a residential setting.
Okay.
Right. Mm-hmm.
So tantamount to an assisted living facility or something. I'm trying to get some sort of analogy. A group home. Okay.
Mr. Chairman, if we may, just for the benefit of the committee, Beverly Rollins, who is the director of the Division of Developmental Disabilities, is probably best suited to answer your questions.
Okay.
If you will.
But we are talking about some sort of residential living facility, as opposed to, which is, in terms of the amount of care that's delivered, I want to see a lower level, but not as pronounced as a state hospital facility. That goes to the need of a patient.
In actuality, the bill is addressing moving from having an individual in a restrictive facility of the hospital to a residence in the community that would provide the same level of care that they would get in a state facility into a crisis respite type home. It could be a 4-bedroom, a 4-person facility, but it would be run or funded by the state, run by either state employees, or it would be funded or contracted out to a provider, a community provider. That could be someone who's a for-profit agency or a non-profit agency that is a current waiver approved provider by Department of Community Health. So that facility would provide the same level of care. We're hoping that the bill will help us to where they won't have to be court ordered to the state hospital, but court ordered to the community facility in the residence would be closer to their own homes as opposed to a state facility that we currently have them court ordered to.
And we might say also that we are not talking about a huge number of people. By far, the most people are served for developmental disability services without any type of court order or legal proceeding. They're just served in waiver services. This is talking about a number of people who, at this point, suddenly have an emergency, temporary and immediate need for services. It's a crisis situation, and they go to a hospital. What we want to do is have the crisis addressed in the community setting, closer to home, smaller setting, more compliant with the Americans with Disabilities Act. So, and we anticipate that there would be probably a declining number of people who even need court-ordered services under these provisions in the code, because our waiver services are going to be increasing in the community. So hopefully there will be fewer crises. But we're not talking about every single person that needs developmental disability services in the community.
What is our posture right now with the Department of Justice or any other federal agency as it relates to the state's delivery of these services within hospital facilities? Are we in an adversarial posture? Are we in a monitoring posture? Are we in a litigation posture? And given that, is that a primary motivator of this particular legislation?
It is, in addition to the fact that the department is going in this direction also, but as I mentioned, the timing is pretty critical for us right now. There is a lawsuit that's been filed against the department, and it's on grounds of hospital services and rights of persons in an institutionalized setting, and they have added a complaint to address the Americans with Disabilities Act and the Olmstead provisions. In other words, they want community services expanded. They want people out of the hospital. We are right now negotiating with them. Negotiations have been ongoing for several weeks now, really a couple of months, more than that, and they're proceeding. This will help us immensely. And
what is their? I'm sorry to interrupt you, but what is their basis for this push on that? Is it a satisfaction with the state hospitals in general? Is it because of some other federal regulatory mandate that we haven't discussed here, or is it? What is the impetus for their push on the state toward making this change? And I know you don't speak for them, but
exactly. I understand.
But you've been in that room, and we haven't.
I have been to some extent. They really are looking at the Americans with Disabilities Act, which says that people need to be served in the most integrated setting possible.
Okay.
And I would say that their issue is it's a national agenda to push the Americans with Disabilities Act with reference to state hospital facilities for mental illness or developmental disabilities consumers. And to push it fast.
Okay.
They are on a fast track, and they are also looking at Georgia in terms of what speed we have been able to use in complying with Olmstead and the Americans with Disabilities Act. They're looking at the Olmstead case having been decided more than 10 years ago, and they think that we ought to sometime back have already been at this position.
Last question, then I'll defer, and I apologize to members of the committee, but I think it's important to get this out there. Are we under any threat of any kind, monetary, administrative, whatever, if we do not adopt this legislation? Which is not to say that we're looking for a reason to not adopt it. I want to know just exactly what carrot stick posture we're in right now, if any.
Exactly. will let Beverly Rollins address the financial issue. My understanding is that we're not having to completely retool our budget and everything to get this accomplished. But as far as the timing, we would not be able to, what I described to you earlier, we need that bridge period where we are developing these community services. Because if we tried to come in next year with provisions like this and say we wanted to have them implemented on July 1, 2011, without having built the community services and without having people already going into designated providers and the courts acclimated to this system and all of that, we just would not be able to implement on that kind of short time frame. And while I don't know specific terms in what the Department of Justice is looking for, they're looking for deliberate speed in what we're doing.
Sorry.
The change in the law is very material to what we need to accomplish.
Mr. Knox.
I'll wait.
Ms. Abrams.
I have two questions, and it follows up on the issue raised by Representative Levitas earlier. The funding for these facilities, is that incorporated already into the state's budget, and do we have adequate funds for those facilities should this take effect?
Mr. Chairman, could I answer?
Yes, ma'am.
Yeah, just say, I have been working, Representative Butler and I last year worked on an infrastructure change, and that was an omnibus bill that was 200 pages. And I have been working with Dr. Shelp, and I think it would have been more appropriate today to have Dr. Shelp become the Commissioner of Behavioral Health to explain to y'all, because I have been working on a daily basis with them in this infrastructure change and changing the laws to coincide with the appropriations. And I'm sorry that he's not here to be able, and also it's my reputation that's on the line before this committee, and I apologize to you for
There's no apology needed. I believe me, when you're, you can only herd cats so effectively.
Right,
we get
right,
that. So,
right.
don't,
Okay.
please don't apologize.
And,
Thank you.
and I would not have brought this. This really should have been a separate bill, and I agree with Representative Levitas. It is pretty substantial. But I was scheduled to testify today before the Department of Justice to tell them what I have done as a legislator through appropriations, through the budget, through working with Dr. Shelp. We have created a council of the interdepartments, of all the different departments coming together. We've met 3 or 4 different times as a group with Commissioner Walker, Department of Corrections, DJJ. And we're making substantial changes, and I think the reason the department wants this expedited so much was to prove to the Department of Justice if we have to wait another year and we have to bridge that gap, that we cannot have the law effective to be able to move these people. Just like down at Milledgeville, we're in the process of closing down the hospital at Milledgeville and improving the department, the regional health department on Panthersville Road. We're trying to make these substantial changes, and I guess that's why the department is putting so much pressure on the legislature. I don't appreciate it, but I'm trying to help them in holding the bill and making sure it's perfected. I agree 100%, and making sure that it's doing what it needs to do. And if you want the governor's office or Dr. Shelp come and explain it to you, that I think that would be very appropriate. But I can assure you that the money is there. We have given Dr. Shelp leeway. Specifically, I know in the Senate, we have not called him to the table. We have said, here's your extra $65 million. You change the infrastructure. You get us in compliance with the Developmental Disability Act. And that's what his responsibility, and he's done a great job in doing it. He has stepped up to the plate and done it.
And it's the Senate's intention to have that preserved within the budget?
Yes.
Okay.
Mr. Chairman, if I can
Yes,
follow,
ma'am.
and if this information can be provided at the next hearing, I just want to kind of lay out what my concerns are. One, it is that issue because both Representative Levitas and I have met with our community service board, and we hear often about the lack of funding, especially for the community facilities. And given the size of DeKalb County and the constrictions in both the county budget and the state budget, I'm deeply concerned about, especially the provisions that are in subsection C of 37420 regarding young people. The second question I wanted to have you respond to, and this is just informational for me. If you look at section 7, it refers to it's first mentioned on line 158. And then again on 171, and this is just an informational. It says that essentially the certificate is ordered to serve the county in which the client is found. Now, let's assume that someone has a crisis in Fulton County. They're a resident of DeKalb County, but the family that can take responsibility is in Cobb County. Who's actually responsible? Which facility? Because where the client is found is a fairly ambiguous term in my mind. So if you guys could provide some illumination either now or later to that issue. And then finally, the last piece is the sort of overarching conversation about the interaction between these community facilities and the community service boards, given the additional pressure that's going to be put on these community service boards given their mission, what's the obligation that they will have with relationship to the change in structure? Because I think, like everyone here, we're not opposed to it, but we have a very local obligation to understand what this means and what the impact will be, particularly given the constrictions on the budget. Thank you.
Could I answer? I face the same concerns that you have. I represent the Gwinnett Rockdale Newton Community Service Board, and it has been cut back too. And that is the same thing that I've been saying to Dr. Shelp. How can you change this infrastructure and move people out of the hospitals? We're kind of in a bad imposition because we've got the Department of Justice saying you have to move them out of these hospitals. You have to move them into community service treatment. We literally have people dying in the hospital. So how do you make that transition to the community service when you don't have the services in the community? So that's what we're in the process of trying to get the laws to coincide with the appropriations, and that's why I think it's appropriate for Dr. Shelp to come, because he's the one that's on the table, because we're the ones that get the complaints of our community service boards being cut back, and here we are putting the pressure on to push them into the community. But if the services aren't there, I know Savannah has a huge problem, and I've answered a lot of calls in the southern coastal area from representatives that have called me saying, Renee, what are you doing about this and this and this? And Dr. Shelp has intervened on those calls for me and helped out trying to make sure that this transition is going to go smoothly.
Mr. Knox.
I've been working with our community service board in our area, and best I've been able to puzzle out from all this is it seems like this has been an ongoing, this isn't something new, we've been dealing with this, but I remember in the 60s when we started all this that we decided we're going to put all these folks in the communities because hospitals were bad, communities are good, and so we're going to take care of them in the community. But we didn't set up any infrastructure, we didn't give them any money, and I'm not sure we actually decided that you could provide better services in the community than you could provide in the hospital. We just said you weren't getting good services in the hospital, and the solution to that was put them in the community. And I'm not sure that's always the case, and I hope we aren't going down that road again, because it doesn't seem like we'll get any better result than we did the last time if we do this. And clearly there's, we need some improvement. But I'm concerned that we just decide, well, hospitals are bad, let's close all the hospitals, and then we'll take care of them in the community, and then the money never shows up. And it seems to me like I've never been understood, maybe somebody can tell me, why a community service board with a facility in the community can do a better job of taking care of that person's health needs than a hospital can if the hospital has the proper resources to do it. Am I missing something there?
Well, one of the things that Dr. Shelp has told me that he's doing is moving towards private contractors and privatizing the services, and they can deliver it at a better cost and more effectively, like moving into the transitional homes, the group homes, and I'm sure you can talk about that. And the mode that he's going is looking at privatization.
And I'm not arguing that. I'm just my problem with it is that as we add more people to deliver the services, which I think it's just a lot more labor intensive to do this in local communities than it is to do it in hospitals where you can take care of more people when you have your resources concentrated in an area. It seems to me now you can only do that up to a certain level, and then you can't do any more, folks. But if we're I think we need to make sure we understand we're looking at spending a whole bunch more money and putting a whole lot more people on this task, and be sure first of all we got the personnel to do it. I think it requires some level of skill. Otherwise they shouldn't be in the hospital if it doesn't require medical personnel to do the things that need to be done. So, it seems to me like if you have to have a three-person shift to take care of 4 people in a residential home, I think it seems to me like that takes a whole lot more manpower and a whole lot more money than if I have the same 4 people in a hospital setting where I've already got a certain level. Am I missing something there?
One of the challenges is creating that environment in the community and doing it where it doesn't cost us more, but cost us less. The number of people that required this service in FY09 was 138. This year to date to the end of February, there's only 78. So we're looking at a population that's not enormous to have to provide this service for. Right now, we're providing this same service in the facility, and we're running an entire hospital to do it. When we can take care of these folk with an average length of stay of maybe 2 weeks or so, and to de-escalate the crisis, and then they can go back into their homes. Now they're in the hospitals and they get admitted to the facility. So it's more cost effective in the community in a smaller setting to deal with the same acute services.
The one thing I do like in this bill a lot is the fact that it looks to me like we're trying to get over this problem of getting people to get help without having to go through the whole guardianship thing and all that business before you can take them to get some immediate assistance. That's a big problem with people who are not compliant with taking their drugs and that sort of thing. So I think that's a real plus. If we get that, we don't get anything else. If we get that, I think it'll help those folks a lot, I would think.
Mr. Thompson.
Thank you, Mr. Chairman. I won't take too long because I think the other representatives have talked about it. But Section 7 and 8, where we're talking about basically committing people against their will, I think, is that process. Are there? It appears that we're giving for the next year the ability to put those people into once again community service providers. Do we actually have the facilities to deal with those people during the next year? I think that's something, if we come back to this next hearing, if we could respond to and say that those facilities are out there to actually deal with those folks.
Some current existing crisis respite facilities in the community already. The bill would just help us to be able to do both hospital and community over this next 12 months in order to increase the amount of crisis respite that we have in the community today. We will have the flexibility that if the service that we currently have is not wouldn't handle the acuteness of the situation, we can still put them in the hospital, but in the hopes of next year stopping providing temporary and immediate care in the facility and just put them in the community.
Is that going to be a residential facility?
Yes.
Are there any figures that you might provide to the committee about, say, in Gwinnett County or DeKalb County, how many beds or how many residential facilities such as that? I mean, I'm aware of one in Gwinnett, but I don't think there are very many people that can be served by that at one time. So.
We have crisis respite homes in each of our regions that are available to folks that need them in each of our 5 regions across the state. The number of homes, I can get that number for you. I don't have it off the top of my head. But we do have some facilities to be able to begin to make this transition from the hospital to the community over the next 12 months. And we hope to be able to increase that.
Mr. Levitas.
Thank you, Mr. Chairman. I have a few areas of concern let me back up very far and echo, first of all, what Chairman Golick said. I want to be very clear. I've only been here 4 years, but in every year that I've been down here, when Chairman Underman has come to this committee, every bill that I remember has in some way been there to protect mentally disabled, mentally ill, developmentally disabled children. And I want to commend you. And I'll make it very, very clear that my questions and concerns have nothing to do with you, and that I have nothing but the utmost respect for everything that you've done before this committee, and I want to commend you for that. And I want to also thank Representative Abrams, even though she's not here, because she articulated the problem much better than I did with regard to the community and state hospital, so I'm not going to follow up on that. Here are my two other areas of concern. One is, it seems to me that with this shift, we are essentially treating CSBs as hospitals. But as far as the licensure and regulatory requirements, I don't see where that matches up. Who's going to be responsible from a regulatory end in the same way that a state hospital would be with regard to the licensure and to the oversight, the regulatory requirements? That's one area. The second, let me let you go ahead and answer that, because my second question relates to Section 8, and there's two questions within that. And if you don't have the answer for that now, if you could bring it to the next committee meeting.
Well, the facilities that we were talking about would all have licensures under the Department of Community Health, and so the regulation would come through there.
Is that the same? Would they be regulated in the same way, both with regard to the regulatory requirements and the licensure, in the same way that hospitals are currently regulated, or is it a different regulatory scheme and licensure scheme for the CSBs?
This is different.
All right.
Right, and I guess that's an area of at least question, if not concern, for me.
That was part of what I was talking about. What the Senate bill last year created was this council of where the different departments, the different agencies are meeting once a quarter and coordinating. It's no different than the Medicaid. You know, Medicaid is, the enrollment is done by DCH, but DHS does the actual implementation of it. So this is no different, and it would be the same process.
Okay.
But that's why that council is so critical to get corrections, juveniles, the Commissioner Walker, and all these different commissioners together once a quarter to coordinate and better facilitate these things, and that's what the governor has been working on.
Thank you, Chairman. My second question, if I may, Mr. Chairman, I know I've asked a lot, but I am trying to expedite this for the next hearing, relate to Section 8, and specifically lines 208 to 216. I want to begin with a very general question, which is that under Chairman Unterman's underlying substitute, there are references both to developmentally disabled as well as mentally ill. And I noticed that Section 8 refers only to developmentally disabled. Do we not need to make a similar finding with regard to folks who are deemed to be mentally ill, or is that covered in some other section?
That's covered in other portions of the law, and the legal proceedings are different for that. You can only really remain in a hospital if you continue to meet the standard, meet the criteria of being continuously dangerous and mentally ill. Once you really are no longer dangerous and mentally ill, you would be discharged from the hospital where mental health services are concerned.
Okay, but and I guess maybe it's, as Chairman Golick pointed out, you're talking mostly to a bunch of lawyers or certainly non-medical folks, so I'm still struggling a little bit to understand why we wouldn't want to make somewhat of a similar finding that you have set up under Section 8. And maybe, again, that's something you can explain to me offline. I don't need to take up the committee's time if everybody else understands that. What I do want to make sure is that with regard to Section 8, paragraph A2, the way I read this, that once they come in, they can be held until the administrator says otherwise, except that they actually have to be released within 48 hours unless this procedure goes through, and that requires this petition for a full and fair hearing, and that they get they've been examined either by a psychologist or a physician. Am I understanding that correctly?
That's correct. That's correct.
So, I guess I guess to me your exception almost swallows up the rule, because you're saying that they're going to stay there indefinitely. However, they actually have to be released unless these things happen. And is it possible, or is it going to be true in every case, that the requirements of the provided, however, will occur within 48 hours? That they will have filed that petition, they will have been examined by, or are we going to wind up saying they're there, but they're not really there because we can't get these things done within 48 hours?
No, sir. That occurs right now. That's the legal proceeding for people who are admitted to hospitals. It would be the same legal process for people in this in the community.
And so there's not a problem currently. There's a similar same structure in place, and these things happen, so we don't have to worry about that.
Right.
Okay. And I guess if that's the case, why the provided however language? Why not? They are going to be released. They're going to stay here until the administrator says otherwise, and we're going to have these things done within 48 hours. Why the provided however language? Because it seems to me that says that if that doesn't happen, then they stay until the administrator says otherwise. So if you don't have the petition, if you don't have the examination within 48 hours, then that person is there indefinitely until the administrator says otherwise. Correct?
I think that this is just a function of the way we needed to put the grammar in and phrase the bill so that we would have the option, so that the people would be taken to community providers. This is saying the same thing that currently exists in the hospital.
Let me put it this way, and maybe this is a question for the author. If the author is comfortable with this language, I'm comfortable with this language, given her background and where I know her heart and her legislation has been. So if the author doesn't have any legislation, if the underlying legislation doesn't have any heartache over that provision, it just seemed to me that provided however language ultimately says if you don't get those things in place within 48 hours, it's up to the administrator to decide when that person leaves. And it's almost, to me, counterintuitive that the provided however language, I would assume, is there in place to protect the rights of the patient by saying you're going to be examined and you're going to have this petition. Yet if you don't, those safeguards aren't in place, then it becomes subject to the administrator to determine when that person is going to be released. But as I said, I'm completely defer, given her expertise and her passion for this area, to the author of the underlying bill. If she doesn't have a problem, I don't have a problem with it.
All right. Well, the sense of this was intended to be the same as in paragraph A, and that is the process is the person is admitted on a certificate filed by a clinician, signed by a clinician. They can be held there for 48 hours. And after that, the administrator, or by the time that 48 hours elapses, the administrator of the facility must file a petition to have the person held there longer, if that is needed.
And I like that language better than the way you've drafted. It's not the same here, and that's exactly my point. If you look at it, it says they'll be there, and then they must be discharged within 48 hours unless certain things happen, as opposed to they're going to stay there indefinitely unless those things happen. So my suggestion to you would be to more closely mirror the language in A1 and A2. I don't read it the same, and maybe counsel can clarify that. Again, if we're coming back and it's not a problem, counsel doesn't see a problem, the author doesn't see a problem, I don't want to make a problem where there isn't one. But that my concern is I like the language better where it says you will be discharged unless, as opposed to you will be discharged if.
All right.
Thank you, Mr. Chairman. I apologize for the length of the question and the number of them.
No apology needed. That's exactly why we're here. Ms. Bird.
Yes, thank you. I am a non-attorney, so I'm going to, on Section 8, lines 202 and farther down, it's very unclear to me, is this not expanding beyond behavioral health?
No, this is all in Section 30 or Chapter 34 of Title 37, which regards people with developmental disabilities. So this applies only to those consumers.
So it specifically says that that's all that it's going to do is to.
The term client is defined earlier in the code in 3742, and that just doesn't show up in the definitions here because it's not being amended here. But this applies to people with developmental disabilities only. Is that answering your question?
Not really, but that's
well,
right.
as long as the word, as long as client is limited to developmental disabilities, we just don't see the definition, Ms. Bird, of client here. But well, unless I've missed it. But I think the concern is that it would expand into other areas beyond behavioral health. Just because it's in a particular title doesn't mean it's limited to that, what it's meant to do. It has to be defined right there. But if client is defined and is limited in terms of its application, then that would be fine.
I think you can look up and see at line 189, the existing law, it uses the word client as well.
And Ms. Bird, we can check on the definition of client in a code. Okay. Does that satisfy?
Yes, thank you.
Okay. Good question. Mr. Levitas.
Sorry, Mr. Chairman, but I do have another one. We refer to physician or psychologist. I'm assuming that what we mean is psychiatrist or psychologist. Is that correct or not?
Physician would include psychiatrists.
Right, and I guess my question is, under this definition, is it you could have somebody who's a pediatric urologist do the evaluation as opposed to a psychiatrist, and it would satisfy the terms of the code section. I'm wondering whether we shouldn't specify the term psychiatrist or psychologist versus physician or psychologist.
That has never been specified before, and typically in practice it's really more psychologists than physicians who do the evaluations for a lot of the testing that's done within the developmental disabilities field. Do you have anything to make this correct?
Well, and I guess I'll be honest with you, there is some concern out there that some CSBs have gone beyond the scope of their what's supposed to be limited to behavioral health. And I know that having talked to some doctors and heard from some of those folks, and not just doctors, hospital organizations as well, that there's some concern about these patients being kept in longer than they should have. And in some cases, and I'm not making any specific accusations, let me be very clear, but there have been inappropriate use of restraints and things that may not occur in a hospital setting that do occur in some of the CSBs. And again, I view them as having a little bit different functions. And I guess that's part of my concern, and I think Representative Byrd addressed this, is making sure that we are not expanding beyond behavioral health the ability of CSBs to provide service to these patients, especially given that there is a somewhat different regulatory scheme in place.
Okay, this is intended just for crisis services for developmental disabilities. Now, and those consumers may certainly need services in other areas, but those services are anticipated being provided in the through waivers, the crisis services through waivers, and other more long-term services that they would need would be typically provided through the waiver. And the waiver services are fairly comprehensive, consistent with federal law definitions, and with the waiver that we have approved through the federal agencies.
I guess, and again, this may just be by virtue of being not in the medical field, but I guess I share Representative Byrd's concern somewhat that hasn't been fully satisfied, that there's not quite the restrictive language in there that maybe needs to be, to make sure that the powers that are being given to the CSB are consistent with its mission, traditional mission of behavioral health, and not expanding beyond that. And again, when you come back, I would suggest two things. One, that we have the word psychiatrist in there, or that we make at least the definition of physician a little bit tighter, that is specific to the appropriate diagnosis. That person has training in that specific field. And I would suggest to you that's a psychiatrist, but if you don't think that's true, certainly something that the way this language is worded, as I said, any physician, regardless of having any experience in psychiatry or psychology, would be able to approve that. So that's one thing. But also, again, the restrictions to make sure that we're being true to the CSB mission.
All right.
I know council had a question.
Yeah, just a quick one. At the bottom of page, this is in section 7, the bottom of page 5 and top of page 6. We're talking about if the family member is unable to take the client safely to the CSB within 72 hours, then a peace officer gets involved, but it says shall make diligent efforts to take into custody the client. And it just seems to me that either, I mean, if you're making diligent efforts and you can't take them into custody, it's a peace officer. I think you could take, I mean, I think a peace officer can pretty much take somebody into custody. So I don't know if you really need to make diligent efforts unless you're going to provide for what happens if they're unsuccessful. So I think it just says shall take into custody the client. So it's line 173.
Basically, the language just copies what's in A, pretty much copies what's in A. I mean, if there's a will to amend A and B, then certainly that would be possible.
I'm not seeing it now. Can you tell me what line?
Lines 160 and 61, is that where you're?
It's 161. It says in B, actually. Yeah.
Oh, I'm sorry.
It's, yeah, it probably is I understand it, but I just don't know what it means.
And again, there was not an effort here to just wholesale, improve the language and make other changes that we might feel would be appropriate or needed. Really just trying to get the bottom line here and close out the crisis admissions to the hospitals so that services would be provided in the community.
Ms. Abrams.
Just following up on that, and this is a question to the authors. It would be my reading that shall make diligent efforts refers to the fact that if you have someone who's in crisis who evades their family and cannot be taken, so if we take out that make diligent efforts language, we're obliging the peace officers to actually take them into custody when they may not be able to locate them or may not be able to. I mean, they're extenuating circumstances that I think require this language. Otherwise, you're creating an act where a peace officer may have an obligation that is not consistent with their duties. Because this isn't someone who's committed a criminal act; they're just trying to assist in the bringing in this person. So, I'd just like us, before we change that language, I'd like to consider whether that change is necessary.
I see no further questions. Thank you, ladies. We appreciate it very much.
We'll appreciate it very much.
And I'll make sure that Dr. Shelp is here when you have the next hearing.
Thank you.
Because I think he can more thoroughly answer. And he's the one that's accountable to the questions that Representative Abrams and
I think what I'd recommend is, as per the concerns expressed today, that it might be a good idea, obviously, for the department and the author to get with counsel to see how we can best tighten up on some of the concerns that were expressed today. Let me ask you one other question before I forget. Do we have any communications, any written communications from the United States Department of Justice on this issue that might be helpful or not to members of the committee on how?
To my knowledge, there's nothing that is, for instance, in relation to our case that could be disclosed, that would be in writing. I can tell you that Sam Bagenstos, one of the higher-up attorneys in the Department of Justice, has made at least one address that I know that's available online, basically outlining the Department of Justice view of CRIPA, which is the Civil Rights of Institutionalized Persons Act, the basis on which the case against us was originally filed, as opposed to or in conjunction with the Americans with Disabilities Act. I can provide a link or a hard copy of that to you?
No, I mean, that's not necessarily. This goes back to our line of questioning before about some of the federal push that get y'all testified has come, which is one of the impetus, one of the driving forces of the legislation. We just wanted to see if there was something on paper that Justice had put down to say.
In the case are available. They're on public record.
Okay. Well, I mean, that again, that's something that we are not aware of,
Yes,
and that y'all are living on a day-to-day basis. The first time we're seeing this, and we're being told this has to be done in part because of a push we're getting on, from Department of Justice. Well, push can be defined in a lot of different ways. There are pushes, there are threats, there are coercions, there are asks, and we're all in the asking business, aren't we? So, I mean, the context is very important as to how we act and if we act and why and so forth. So, we need as much information, if it exists, as possible. So, we're not scraping through our website, pouring through websites to look at pleadings. We're looking at what are the ramifications or consequences of X, and what are the ramifications and consequences of Y. That's all we have to go on. That's all we can go on. So I just want to make sure it's clear as to how we're looking at it.
Mr. Chairman, I
yes,
think
ma'am.
it might be appropriate if we also had the governor's office and legal counsel from them come.
So sure. Yeah,
that might clarify some issues.
As much perspective as we can get is always welcome. I know Oliver Hunter from the Georgia Sheriff's Association wanted to testify on the bill, and Mr. Hunter, you're welcome. And ladies, thank you again.
Thank you. Thank you.
Mr. Hunter, welcome.
Thank you, Mr. Chairman. I'm Oliver Hunter with the Georgia Sheriff Association, and I'll try to be as quickly as I possibly can. I had not planned to testify, but there are some things here that really, I think, have to be addressed. If I can follow up on Representative Abrams' comments earlier about the language about get my place here. Making diligent efforts. In many instances, it's not an issue of actually being able to physically arrest the person or take them, because it's locating. And the diligent efforts refers to the ability to actually locate the individual. So I would request that you not change that language, because it provides us the ability to not have an absolute duty if in fact we can't locate the individual. So I appreciate that. But if I can make some fairly general comments about, it starts on section 7, lines 167 through really 184. If I may, indulge me just a little bit. Presently, the sheriffs have the obligation to receive certificates called 1013s and actually go out and pick up individuals for involuntary treatments. And we take them to the nearest emergency receiving facility where they are actually received emergency treatment. If further treatment is necessary, they are transferred to a what they call a treatment facility. That statute, that instance has been a great consternation to most sheriffs, because what happens is that in most instances, the certificate states that they take them to a place that's not the nearest one. And to go back to your language, for instance, it says on line 171, if such responsible family member or representative is unable to transport the client safely or is unwilling to transport the client, any peace officer within 72 hours after receiving that certificate shall make diligent efforts to take into custody the client named in the certificate and deliver the client to the nearest community service provider. That almost identical language is contained in the statute that pertains to 1013s. And I can tell you, this will fall on law enforcement. Family members will not, for the most part, make the transport. And we are basically put in a position of providing ambulance services for folks who in many instances are not a danger to themselves or anybody else. It's just a matter of convenience to have the sheriff to make the transport. And my concern is that if we can, while we have the opportunity here, if we're going to go with this language, I would like to see some language inserted here so as that if our duty is merely of transport, we don't have to transport beyond the nearest. Our duty is simply to the nearest community service provider, and that we not be required to wait. Presently, and please indulge me because this is a matter of great concern to all of our sheriffs throughout the state, where we have had to wait hospitals for hours and hours and hours trying to wait for the person to be received. In many instances, they say, well, they got to be cleared for medical transport before we can take them, meaning that it makes sure the person is not hypertensive, diabetic, because we don't want them in the back of a patrol car while they experience some medical issues while we're trying to transport them for a mental issue. Well, that sometimes in many instances requires us to wait while the person is cleared medically before they can be transported for their mental issues. And my fear is that we're codifying into law what doesn't already work anyway. It's not working for it to hospitals, and we're about to codify into law a practice that doesn't work already.
Well, just to be clear, I mean, it does say to the nearest community services provider. Are you saying that the client named in the certificate, that by virtue of getting to the certificate, that there's a delay there?
I'm saying the certificate in many instances will not name the nearest one. It would name someplace other than the nearest facility.
Okay. I mean, I think that's a matter of my sense is that that's a very easy cleanup, especially given the fact that your mandate under the law enforcement's mandate, which would end up being the sheriff's mandate, I assume, would go to the nearest community service provider.
I don't want to make this more difficult than it is, but I can tell you from the past 10 years that when it says the nearest emergency receiving facility, they will sometimes name places 3 and 4 hours away. They're saying beds are not available. This is not available, so the nearest one is 4 hours away. I think we need some tighter language here, so that in terms of where we're coming from, that our obligation is clear. And sheriffs don't mind making these transfers, believe me, especially when there's an issue of safety involved. But we don't want to be crisscrossing across the state as we presently are, and waiting in hospital hours and hours and hours.
I mean, and I'm sorry to interrupt, but I mean, would the cure be client name in the certificate in some language to the effect of such certificate shall name the nearest community services provider? So the certificate must, within the language of the certificate, it must name the nearest community services provider, and then the mandate upon the peace officer is to deliver to the nearest community services provider. Is that where you're going?
Well, that's the law now as related to hospitals, but it doesn't happen.
Well, I'm saying the community services provider, that you would simply want the certificate to include language
that would be helpful.
That would name specifically the nearest community services provider, which would match up to the mandated language on peace officers to deliver to the nearest community services provider. Is that generally where you're going?
It's generally where I'm going, but,
okay.
but officers feel compelled to comply with the certificate.
Right, but we can. My point is that the certificate, it would be mandated under your theory right now, or what I hear you asking, is that it would, within the certificate itself, it would name the nearest community services provider. In other words, that would be
helpful. That would help in some measure. Yes, it'd be helpful.
I'm just trying to get to the heart of your concern.
My concern is that, first of two, that the certificate names the nearest facility or the nearest community service board, and also there'd be some limitation as to some definition of what our duty is to deliver, and not to wait, not to. And I'm not sure if you can. Maybe some regulations could be augment this, because I'm not sure if there'll be appropriate something in law. But I would like for the regulations at least something to be augmented in some way, so as to reflect that our duty is one of transport, not of terms of actually having to make ancillary kinds of transports to relate to medical clearance, or wait while for hours beyond, some kind of time limitation of some sort.
Let me ask you a hypothetical. What if the circumstances of the situation dictated a transport to somewhere other than the nearest community services provider? I mean, what if the facts of a particular situation, and those situations are, what if it warranted not going to the community services provider? What if it did warrant going to a hospital, which was further away?
Yeah, well, that'll be a 1013. We do that all. We do that presently now.
Okay.
Yeah, yeah. But and I know many of the things I spoke of probably are not best codified in law, but ought to perhaps be reflected in the regulations. And so I'm not too sure what how the companion I know DHR has regs how they do this, but my concern is first that the certificate actually reflect the nearest community service board, and secondly, the regulations are somewhere in here that we say something that concerns the time constraints, how many hours. And I know hopefully we're improving as we speak in the hospital, but our officers have waited hours and hours upon hours, and for small agencies, that's just something they can't handle.
That's something I think I would invite you to visit with the department and the author on in terms of curative but practical language that reflects the real world situations that could occur.
Yeah, and I only mention this because I had not planned to speak, because no one's approached us about this. This is my first time seeing this.
Me too.
And I would have been glad to share this information, because I tell you what we're about to codify is something that presently is not working. And why would you want to codify something that's not working as it is now?
Ms. Abrams.
I'd like to respond to a few things. And with all due respect to Mr. Hunter, I think some of the things that you want to solve are solvable. Some of them are not. I would point out that the existing language is included on line 162, which just says it has to deliver the client to the nearest facility serving the county. That's what's going to be effective prior to June 30th, 2011. The new language wouldn't take effect until after June 30th, so after July 1st, 2011. So even changes that we make within this bill wouldn't codify any changes, because there is no community service provider that can solve this problem right now. So I just want to make sure we're clear that the way this is structured, some part of this refers to what happens after July 1st, 2011. The second part of it is that after July 1st, 2011, it does include the language saying that it has to be the nearest community service provider designated by the department. I think the challenge with having the 1013 actually list the provider is that goes back to my earlier question about where the client is found. A client may be found in a county that is not listed in the certificate. It is the obligation of the peace officer to take that person to the closest designated facility, but you cannot list which facility that is because you don't know where the person is. So if the person is if the certificate is issued in DeKalb County, but the client is found in Bibb County, the obligation is not for the sheriff's department in Bibb County to drive that person back to DeKalb County. So I would push back very strongly against trying to cure this by listing the actual facility, because the entire point of this is that you want to get that person to the closest facility that is designated by the department to be a service provider for this purpose. The last thing I would point out is that if we try to remove the requirement for medical transport, part of that is to protect the sovereign immunity of peace officers. If you don't follow those procedures, then let's say you just drop someone off. If you had any reason to know that that person may have had some intervening medical history, medical issue, you run the risk of vitiating your sovereign immunity for your department. And so I would be very careful about how we engage that conversation and try to put into code the fact that you don't have to wait while they're being treated for something else before you take them somewhere. Because in Atlanta, we've had that problem a few times.
Perhaps I misspoke. I'm not saying that. No one understands that more clearly than we do.
Yeah.
The medical clearance must be taken care of.
Okay.
What I want to make sure is that we are not responsible for that transport. That transport should be taken care of by DHR.
But I think the challenge there is that there are only two groups that are authorized under this legislation, either the family or the peace officer. If the peace officer has custody, achieving the medical clearance, and what I would suggest is just thinking through that and making sure that we're not creating a situation where medical clearance basically interrupts the transport, and if that's not what you're intending to say, that's what I heard. So I just want to make sure we're clear that we can't really interfere with that.
I may misspoke, because you're absolutely right. And in terms of the immunity, what I'm saying is that we do not take custody of the individual until such time they're being transported pursuant to the certificate. Okay. Any clearance for medical should take place prior to our even receiving custody of the patient. Is what I'm saying. We should not be engaged prior to that. When we show up, we should be ready to make the transport.
Gotcha.
That's what I'm saying.
But how does that enter? I'm sorry. Do you want to hold this for next time? But how does that engage with the issue that if you've got, because some of the situations that we face in the city has been that you have an officer who has to pick someone up who has a medical issue, and before they can be, particularly if you're taking someone to a community service provider, if they've got a medical issue that, and you let's say that the sheriff picks that person up, you note that they have some medical issue that has to be dealt with. You've got to get it, and under the 1013, before you can take them to what would now be a non-hospital community service provider, you've got to address the medical issue. Because my concern actually, and I may be going somewhere that you weren't, if we include language about medical clearance, if you pick up someone who is hypertensive and schizophrenic, and you've got to take them first to the hospital, and then they also have to go to a community service provider. My concern is that once you are the peace officer who has custody of this person, you've got to get them to their final destination designated by that certificate, whether or not you're going to run the risk of having to wait a lot longer because you've got to go to two separate facilities before you can get them where they need to be.
My point, the only point is that we should not be engaged prior to the patients being ready for transport. The protocol is that they should be cleared medically before we are engaged. So if there's a hypertensive issue, a diabetic issue, they should have that treated before we are engaged. There won't be an issue of having custody of all, because we shouldn't be called engaged until such point those issues have been addressed.
But what if this is a person who's on the street and you're picking them up because a family member has notified you that they need them to be picked up and they are on the corner of Peachtree and Pine?
Well, my point is that I guess what we're trying to get back to the mission, the core, is that is the diabetes or is that a law enforcement issue? This person needs medical assistance, and that should not be the responsibility of law enforcement to transport them to places for their treatment. We don't mind making, in fact, we're delighted to be as helpful as we can as the law requires us to be. But in those transports where it's clearly a medical issue,
okay,
and nothing but a medical issue, we ought not be making that transport.
Okay, thank you.
Let me ask representatives of the department again. I should have asked this before. If you said it, I may not have stuck. How is it that we're seeing this amendment with this kind of breadth and substance here on this side, as opposed to when it was originally considered in the other body? I mean, the timing of that is of concern. In other words, this amendment's coming at the House committee at day 30, whatever we're at, and I'm just a little concerned about the weight and breadth of the amendment coming so late, as opposed to having had it considered on the other side. Is there?
I understand. It really has to do with the timing of our conversations with the Department of Justice.
Okay. All right, Mr. I
apologize for that. We certainly would always want to come as early as possible and have you better prepared before any hearing on a bill. We understand your need, and we support that need to have everybody well educated, but it's just the timing we're presented with.
All right, Mr. Levitas, thank you.
Thank you, Mr. Chairman. And I want to echo something that Oliver said, or maybe he didn't even get there, but we have been, in my short time, and I know well beyond that time frame as well, we've been dumping more and more responsibilities on sheriffs without having funding to back it up. We give you guys more and more to do and fewer resources from the state to do it with. So I'm very sensitive to the concerns you're talking about. I want to follow this a little bit further, because I'm not even sure how naming the facility is going to help. What happens if we name the facility, and as you said in your testimony, they said there's no bed spaces? At that point, are we putting you in a position of saying you got to dump this person by the side of the road, or in reality, since y'all aren't going to likely do that, you now have custody and control over this individual with no place to take them unless it's 4 or 5 hours away? And
that's precisely what happens. We either have to take them wherever we can find a bed, be it in Rome, Georgia, or Valdosta. We'll be at the mercy of taking it wherever we can find a bed of space to do it.
And that presents two issues for me. One is cost sharing. If you properly belong in Bibb County and you're in Cherokee, it's not only the cost that ought to be shared either by the state or by the counties between them, but secondly, that sheriff or that deputy sheriff is now one less deputy sheriff on the road to do the things that you need to be doing to protect citizens. So I guess in thinking this through, we need to figure out not only is there a way to end your responsibility if there is not a facility available right there, and if so, what do we do with that patient who needs the transport? And the answer to me is not we can't fix it reasonably, so you guys are stuck with it. That's not a good answer. So if between now and then you can help us think through in terms of language what we can do, I would certainly appreciate it, because I am very sensitive to the situation that you find yourselves in.
Thank you. You hit the point on the head, and I apologize because I just saw this language. You don't want to be obstructions in
No,
any sort.
it's not taken that way, Mr. Hunt. Let me be very clear. We're all seeing this language for the first time this morning, and that's all there is to it.
And I know we're under pressure to the Justice Department, but this is something that
No. That's an eye of the beholder determination as I see it right now.
But I can tell you this, that we're about to codify another provision that mimics an existing non-working law, essentially. And this, if in fact we had the resources in place where every county had a CSB, or we had, this may work, but that's not the case that I'm aware of. I don't know how the resources are being in process of being placed locally where you could have that issue taken care of. But I think we sometimes away from that just yet. And until that has happened, this is going to make the bad situation almost unconscionable.
Thank you, Mr. Hunter.
Thank you so much. I apologize again. Thank you very much.
Not at all. Please don't. Is there anyone else who'd like to be heard on Senate Bill 391? Seeing none, thank you, committee members. We're adjourned.